It's my pleasure to share how to protect software IP in China. In this session, we will cut through the myths and outline the practical steps to secure software assets in China, specifically intellectual property assets, from source code protection to navigating local enforcement mechanism. And I hope you can see the slides I share here. So why IP is important for software? IP is important for basically all the industries, but why specifically for software? First of all, like all the other industries, IP is an exclusive right. If you have IP rights in China, that grants you to exploit your software assets in China. And a very practical reason is that software copyright registration certificate is required if you want to launch your launch your app in Chinese app markets, such as Huawei online markets or the other similar even like the Apple app markets, the Chinese version, you need the copyright registration certificate in China. And software IP attracts partners and investors. Clear IP rights enable licensing agreements, joint ventures, as well as technology transfer without your partners being afraid of IP infringement. And software IP generates additional revenue streams, like that. From the licensing, you can collect the royalties. And these channels will be more available for you if you protect your software IP in China. And an IP granted your right to prevent competitors from using your software ideas. You can always choose to take action against infringements. Therefore, it's important to consider protect your software IP in China. And I hope you can see it now, and I will move forward to the next slide. That's the important information. It's simple, but it's the core idea of why and how IP function in China. Those three IP principles. First is registration, second is territorial rights, and the third is first to file. For most of the IP types, specifically trademarks, patent, without registration, you do not have the rights in China. For copyright, the rights is automatic, even though it's created in Europe or anywhere else around the world, it's still protected in China. But we still recommend you to register copyright in China just to make the future enforcement a possible options for you when you encounter infringement. Second, intellectual property is territorial rights. That means if you have Europe trademark patent, that doesn't mean you have those rights in China. You still need to go through a separate protection procedure to make sure your IP is protected in China. And the third principle it might be the most famous one, first to file principle. It's different from first to use. That means whoever is the first to file the IP in China, and then they can get the registration. That means their IP is protected, and they will be the owners of those IP. This principle, first to file, is one of the reasons why bad faith registration trademark is so common in China. Because if for those European companies who do not register their brand name in China as the first one, someone else might do it in China, and they will claim they are the owner of that brand name and keep using that in China. It's still possible to clear those bad faith registration, but it takes extra time and extra money, and for the EU SMEs, it's not really visible to clear those bad faith registration. Therefore, the most cost-efficient solution is always have your IP firstly filing in China. This is the most efficient way to protect your IP. And in the context of software, what type of IP can be considered? First is the invention pattern. You may be surprised for certain types of software, they can be patented in China. Later on, I can go into deeper what types of software can be patented. Generally speaking, is those software can be regarded as new technical solution. For instance, this is just an example, unique cryptographic protocols or transaction processing algorithms. As long as they are new and you create it and they solve technical problems, you can consider to patent them. Utility model is one type of patent in China, but for software company, this type of patent is much rare. So I will not go into utility models today too much. It protects the functional aspect of the product. And third is design pattern. It protects the aesthetic aspects of a product. It might be more common to apply it in the industry of like furniture or design. However, for the software, which has the graphical user interface, GUI, you can also consider to patent it as design pattern. And for trademarks, it applies to your brand name, brand logo. And in the context of Chinese markets, you should consider to come out with a trademark in Chinese and register in China to protect it. If you don't do it, the market will come out with a Chinese name for your brands, and it will be much difficult to control which Chinese brand name the market come out for you. And you cannot claim you are the owner of that brand either. So take a more proactive action to consider and register a trademark in Chinese for your brand. Copyright is the most common IP to protect software. Keep in mind that copyrights only protect the source code of the software, not the core idea. Besides source code, it also protect the end user documentation, but source code is more common. When you apply for software copyright, you will be asked to submit the first 30 pages of the source code and the last 30 pages of the source code. For a lot of information, such as data and algorithm source codes that you don't want to be protected as copyrights in China, you can consider to take measures to protect them as your trade secrets. Later on, I will introduce what steps you can take to protect those information as trade secrets. As I said, copyright is the most common IP when we talk about software IP. So what type of information you can protect it as software copyright? First is, of course, the source code, and you can protect it as copyright. Second is the algorithm, but not all the algorithm can be protected as software copyrights. It has to be integrated into source code of software. And for database, only certain type of database can be protected as software copyright. Specifically, if the database can be regarded as the compilation works, then it can be copyrightable. What type of data can be copyrightable? Basically, it's two types. First, it has to be a collection of data. Second, those data is arranged in a way that adds to the value of the data. For instance, for the database that includes all the information of user and in a certain order, such as time, you can consider to copyright those data as compilation works. And a lot of European companies would come to me. They use AI solution to develop their software. So for the AI generated content, whether or not is copyrightable is debatable. It's not only in China, I believe it's around the world. However, it's accepted in most of the country that fully AI GC, no human inputs. It's not protected by copyright. I think it's understandable. But if AI it's only used to assist to generate the content, such as AI generated art edited by a human, AI assisted writing with substantial human revision, then you can consider to copyrightable because those AIGC, they are more likely to be expression of author's original creative choices. So not all the AIGC can be copyrightable. It depends on how much efforts or how much contribution AI inputs into the final products. And software copyrights in China is automatically protected in 181 countries because of the Berne Convention, and China is one of them. So even though your software is created in Europe, you can still have those rights in China automatically. And the software copyright registration is important in the enforcement because they will serve as the prima facie evidence. That means unless there is otherwise evidence, all the information in the software copyright registration certificate should be deemed as authentic and correct. And it's free to get the software copyright in China, but what I mean free, it's that the government does not charge anything. But if you hire a lawyer, most likely it is local lawyer to help you to submit the software copyright, then apparently you need to pay the lawyer's fee. And it's rather fast to have it copyright in China. Only takes 1 or 2 months to get the registration. However, 1 or 2 months, it's still rather slow if your project is urgent. I do meet one of these company that's which engaged in the game software, and they work with they work with one of the first tier Chinese software companies to launch in Chinese app, and the Chinese companies asked the European game software company to provide the copyright registration as soon as possible. That means, by that I mean in a week. And the European company does not realize that they need a software copyright registration. They did not even realize that's a thing in China. And to get that in a week, to get the copyright registration certificate in a week, apparently it's very impossible. Therefore, they come to me and ask whether or not there's another option. Unfortunately, they still have to go through the registration procedure, but there's always a way that you can contact with the copyright authority to ask whether or not they can speed up the procedure for you. But again, I would recommend you to have it handled by the local IP experts. And the software copyright lasts for 50 years in China. It's not 20 years, it's not 70 years, it's 50 years. And you protect the source code, not the core idea behind the source code. And besides copyrights, you can also consider to register certain part of your software as patent. But not all kinds of software can be patented. Apparently, like the game company I just mentioned, patent is it's not an option for them because their software does not solve a technical problem. They did not use the technical means, and the software did not achieve any technical result. However, if your software can satisfy this criteria, you can always consider to patent your software in China. So according to the patent guideline in China, there are 4 types of software can be patented in China. First is the computer programs for industrial process. Just give you an example, like a method of controlling a rubber molding process using a computer program, enhancing the quality of the product greatly. Second type of software is those software to improve the internal performance of computers, such as a solution of expanding the storage capacity of computer using a virtual device file system. And the third type of those patentable software is the software to control, measure, or test that include controlling, measuring, or testing processing, such as using a computer program to analyze the signals from the sensor and measure those viscosity of the liquid more accurately and in a quicker manner. The last one is the software to process external data, such as the software that can remove the image noise and achieve higher resolution by inputting the pixel data of the image in the software. And patent your software is a very technical procedure. You should always consult with a local patent attorney. You can come to me first, and however, we are not allowed to file any application for you. I can give you information like what I give you today. I also lead you to those patent attorneys. And if you already if you are sure that patent is one of the IPs you want to protect in China, then you can choose either the national route or international route to protect your patent. If you choose the national route, that means you will only have the protection in China, and your application will only file directly with the Chinese authority, which is CNIPA. And if you have patent already in Europe or in US, you can still extend your patent to China within 12 months of the application date in Europe or in the US. And if you want to protect your GUI, then the priority claim should be made 6 months after you file in Europe or in US or the other countries, which is part of the Paris Convention. And if you choose the international routes, that means you want to protect more than one jurisdictions. Usually, if the market, your target market is over 3 countries, then I will recommend you to go through the international routes because it's still a bit more expensive than the national routes. You can consider use PCT to protect your invention patent or utility model. For software company, it's most likely it's the invention patent. Or use the Hague system to protect your design, industrial design. Then your international design could be protected in multiple countries. And trade secrets, it's another important and very common solution to protect software IP. What type of information you can consider? That includes unpublished algorithm data and source code. It has to be unpublished, even though unpublished not only in China but also in Europe and other markets. It has to be unknown around the world. So there are some steps I list here that you can consider to take to protect those information as trade secrets. It is not an exclusive list. You can always add more actions you can think about. First is the categorize of those business information as confidential, and you as the right owner, you should control the accessibility of important documents, and you grant the access to core data based on the principle of least privilege, which is the need to know basis. Not all your partners or all your employees has the access to go to visit those unpublished information. And you should apply data masking or anonymization to sensitive information before you share with your employee or your partners. And you should also implement robust IT security infrastructure, ensure all assets and operation are traceable. And one of the common way to leak those trade secrets, it's from employees. I would say more than 90% of the trade secret leaking situations from the employees. So also control and making sure your employees understand your expectation and the protocol to protect the trade secrets. And for those employees who leave the companies, you should timely revoke those employees' device and account assets. Otherwise, it could cause big loss to your company. And the most common way to protect your unpublished information is always NDA, NNN, or the other agreements that can make sure your partners will not disclose those information with your employees. Consider to sign non-compete agreement. And those are the common mistakes when European companies signing NDA with the Chinese partners. It's not necessarily only applies to software companies, but also generally speaking, majority of the European companies will make these mistakes. First, and the most common one is not including Chinese version of the NDA. If it's only in English, most of the time it doesn't affect your partners sign it, but it does affect whether or not they understand what does the NDA mean to them, unless your partner's English level is extremely high. Therefore, I will always recommend having the preparing the Chinese version of the NDA. Second of all, not using Chinese law as the governing law, because IP is territorial rights. If you don't use IP, the Chinese law to governing Chinese IP, then it might be enforceable. It might not be enforceable in China, and in some NDA, it's not specifying penalties such as damages, termination, for if the counterparty, for instance, infringing your IP by reverse engineering without your authorization. If in your NDA you only mention that reverse engineering is forbidden, the punishment is not enough. You should make the damages clear enough. Similarly, you should always include liquidity damages for breach the NDA. And the last mistake is not including return or destruction of all the materials upon demand, especially after the termination of the contract. And this is not relevant to specifically to IP, but it's a very important step to make sure you find the right partner and they protect your IP as well. First of all, which is the due diligence. So how to do due diligence to Chinese business partner? There is an official database run by the Chinese government, which is the National Enterprise Credit Information Publicity System. You can use this system to find out the basic information of the Chinese partner. However, this database, as far as I know, can be only used in China, and it will require a Chinese phone number to log in. So you can either contact the public institutions or contact us, help desk, or contact your embassy or chambers of commerce to see whether or not you can use their services to access to this database. And what can this database provide? It can provide a legal representative of the Chinese partner, which is important because when your Chinese partner sign the contract agreement, NDA, either contract, it's best to have the legal representative to sign it. If it's signed by sale or by manager, usually later on the Chinese partners, they can claim the signature is not valid because they are not the legal representative. So making sure you know the legal representative before signing any contract. You can also see the register capital of the Chinese partner, what business types, what kind of business they are doing, and you can see the date of the establishment. You can also see the shareholders, and it's important things to see whether or not this company is in normal operation. Because, for instance, this company is already bankrupt and they still in a negotiation with you, then it's a big red flag. You shouldn't work with those bankrupt company. This information can be searched from the database easily. You can also see the historical disputes of this company, this Chinese company, whether or not they are involved into any litigation case such as IP infringement or such breaching any contracts. That's a very important factor when you consider working with this company. And you can also read about their annual reports. However, one thing you may not be able to find from this database unless this Chinese company made a decision to publish is the turnover. Unfortunately, the financial records, it's not something that they have to publish online. You can only search online that they are in normal operation or not. Yeah, for this information, you cannot find from this database. And here's just some practical tips when you have meeting with business partner in China. Again, it's important to protect your IP and trade secrets. Before the discussion or transfer any technology information, signing the NDA, and also doing the background search, due diligence, like we already mentioned. And also when you share the information with your partners, it's better to have them view at your business premises at a later stage, instead of sharing with them online without any redaction or without any limitation of access. Or you just share with very rough sketches or very general idea without going to the core idea. And when the negotiation reach to a certain stage, you should sign the MOU outlining the structure of the deal. And in the final agreement, that's the most important one, the agreement should identify who owes what information, who owes what type of IP, and what type of and if for the developing IP or share development IP, which party owes which part. Those information you should also put into the final agreement, and the non-disclosure obligation of both parties, of course. And out of the signing the the contracts, you should continue to monitor your business partner and pay announced visits every now and then. And we already cover copyright, patent, as well as trade secrets. And you should not miss other IP, trademarks, and industrial design. I already mentioned trademark is important to protect protecting your brand name in China. Do it quickly as soon as possible before coming to China to avoid the bad faith registration. And you should also conduct the trademark search in advance before the registration, making sure your trademark still be registerable in China. And for the software company, highly likely you will go with the class 9 and class 42, which is similar as the European class in China, because China also apply this classification of goods and services. However, one thing which is very special in China is the subclass principle. So each class will be divided into different subclass. Generally speaking, if those two goods, for instance, like software and licensor, they are both in class 9, but software in subclass 9.1 and sensor it's 9.10. They are in different subclasses and they are not similar goods. And that's important for you to register your trademark as well. So you can ask me again which subclass your product's in, or you can ask your IP expert in China to do such research. And also class 42, subclass 42.20 is software development services, which is highly likely relevant to software company. And if you decide a very specific GUI, go ahead and register those GUI as industrial design in China. And lastly, I want to go through the remedies for software infringement, which is the key concern from a lot of European companies. But interestingly, we did not receive many software infringement cases, as you may expect. However, you should still prepare that in someday in the future, your software might be copied in China and sold online without your authorization. In that case, what options do you have? And to prepare that situation, what you can do. So if you identify any software infringement, first of all, you always collect and preserve the evidence, all right? Because these steps, it's very important in the context of enforcement in China. Not all types of evidence can be accepted by the Chinese authority, especially if you decide to go to the courts. They have a very, very high requirements for the valid evidence. Basically, you should have the evidence notarized. That means you need to involve public notarial to notarize your evidence. And if those evidence online for software, most likely it is, then you can consider to use blockchain technology to have the timestamps on those evidence to prove either you are the owner or you are the first to use those software information, or those blockchain can also be used to fix those infringement evidence. Those blockchain evidence is widely accepted by internet courts in China. And what kind of remedies options do you have after you collect all the evidence? First of all, if your software has been sold online without your authorization, you can contact the e-commerce platforms or the website service provider to ask them to take down those infringing link. And this is a procedure that's provided, by all the e-commerce platform or online service providers in China. And it's a very quick solution. You can do it yourself. You can also have your local IP lawyers to do for you. And usually the conflicts can be done in 3 days. And if this solution doesn't work, then you may consider to send a notification letter to the counterparty to let them know you notice they sell your softwares online without your authorization. You want them to stop it. And I have to be very honest to you, these letters usually don't work. Then you have to go to a more serious letters, which is cease and desist letter that is drafted and sent and handled by an IP lawyers. In most of the case, cease and desist letters works much better than a notification. And if you want to involve the Chinese authority in, then you can consider to use the administration such as administration for market regulation. However, it's rather rare from my experience. But if I do witness some of the software companies get the administration for market regulation involved to investigate or to raid in the warehouse, or to have the police to get involved to collect the evidence. This option is usually it's usually not that well known among European companies because it involves the administration, and European companies are not sure which administration they should come to. But again, ask your IP lawyers; they will know it much better than you do. And if in the NDA there is any clause mentioning about the meditation or the arbitration, mediation or arbitration to solve the dispute, then you can use those ADRs to solve your conflict, to solve the infringement. And this ADR, which is in case you don't want to go to the litigation, ADR usually it's a very efficient way to solve the problem. And litigation is the last resort in most of the IP conflicts case, because litigation takes a long time and you expect to spend a large amount of money. What I'm mentioning, it's over 10,000 euros to go to a court case. And however, if you win the case, then it's possible the courts will order the infringer to pay the compensation up to RMB 5 million. That's around 600,000 euros. And in other enforcement actions, this kind of compensation is not available. So that's the advantage of litigation. I already mentioned about the evidence collection. I just go through a little bit deeper into what type of evidence you should pay attention to. First of all, it's of course the IP ownership. If you have registration certificate, trademark, patent, copyright, then have it prepared by hand. And you should also preserve the use evidence of the owner, like how you use and when did you use those software, including sales records in China, Chinese media coverage, social media presence on Chinese platforms, and dated records of use. That will be very helpful to for the courts to make the decision whether or not you own this IP, whether or not you are the firstly use of this IP, and and to what extent your product is well known in China. All these factors are important to make a favorable judgment to you. And of course, the infringement evidence you should also well collect it. And here I just want to share one case study, which is the real case study about European companies who come to us. And this company is in chemistry industry. They licenses the know-how, including software, to Chinese company to build out chemistry plants. And they do a very thorough, a very comprehensive background searches into Chinese partner, and eventually they decide to work with a first-tier Chinese company. They besides the distribution agreement, they also sign a separate agreement authorizing the Chinese partner to handle the enforcement in China in case of any IP infringement. In this case, it involved the trade secrets. So they take measures including documenting, making sure all the technical documents are delivered using double strong encryption with triple encryption used for key equipment. And only the need to know employee and partner has the access to visit those documents. And the technical documents contain hidden markers that identify them as IP. Unfortunately, infringement still happened. It's from former employees, which is the most common leaking channel. The former employees from their Chinese partners in key position, after leaving the company, they stole the confidential documents and sold to a new plant in another province. And the SME and the Chinese partner decided to take enforcement actions together. And they filed a complaint with the Public Security Bureau, which is the police of the districts of where the former employees was. And the police started the investigation to obtain the drawings because for most of the trade secrets case, collecting evidence, it's a very difficult job to do, and you need to involve administration. And the police also hired expert witness, confirmed the similarity of the technology, the trade secrets infringement. And the police issue a countrywide warrants to search and arrest those two former employees. One of them was arrested. The other is still at large. However, regardless all the efforts they put, regardless the fact that the police is involved, the new plant still process with the installation and has now commenced production. That caused even bigger loss to the European companies and their Chinese partner. And cross-province coordination slowed down the investigation, and now they are waiting for further notice whether or not the investigation will continue. And the SME file a criminal complaint in EU member states, probably will involve Interpol, the international criminal police organization in this case. And the SME also contacted embassy in China, Chamber of Commerce, and of course help desk us. From this case, we can learn that you should take various measures to protect confidential business information as trade secrets. And the leakage of trade secrets by employees, especially former employees, is the most common case. And you should make sure to sign a confidentiality agreement and the NDA with the employees in key position. It's not cheap to enforce your rights in China. Like I mentioned, you may expect to spend more than 10,000 euros. However, if one does not stop the first infringement, more infringements will be attracted in the future. Therefore, it's still important to stop the first IP infringement, regardless it's expensive. For EU SMEs, when encountering IP infringement in China, it's recommended to contact IP expert to assist. Lastly, I'll leave some takeaway messages. First, audit your IP assets. For trademark and patent, make sure you register those IPs. And even though copyright is automatically granted in China, regardless it's created in Europe or China, you should consider copyright record in China. Consult a patent attorney before patenting your software. Not all types of software can be patented. Taking measures to protect the confidential business information as trade secrets, and evidence collection and preservation is important. Talk with the IP experts. If you indeed have an IP infringement case, or contact us, we will provide free of charge services and guidance to you.